They barely managed to get it through. It's really hard to see how the law survives as it is once the mandate is gone. And just politically, I've posted on the blog that the worst thing for the Obama administration was when the Supreme Court took the case on an expedited schedule such that a decision will be rendered in all likelihood by the end of June in time for the election, because there is no good outcome to this for the Obama administration. If the mandate is upheld, if for whatever the reason all of our prognostications based on the questions asked at oral argument turn out to be wrong, that will motivate the Republican base and the conservative base like nothing else, because then there will be no hope of getting rid of the mandate via the court system. The only way to get rid of it will be the ballot box in November. So if the Obama administration wins on the mandate issue, politically it doesn't help them. And in fact, that's a point I think James Carville has a column over at CNN making a similar point.
Right.
That if they lose the mandate, okay, while it may, tamp down a little bit the excitement for November, it will be such a devastating blow. Basically, Republicans and independents will be able to turn to the Democrats and say, you wasted 3 years of our national life. That we told you this was unconstitutional, you scoffed at it, you called us stupid, you told us there were no legitimate constitutional concerns, you called us names, you wasted almost 3 years of our national life focusing on something that has been thrown out by the Supreme Court. So that's not a good narrative for the Democrats. So once the Supreme Court took this case and put it on a fast track, to me it's a no-win for the administration. Politically, I think they're almost equal losses for the Obama administration. Either his landmark legislation has gone down in flames, or it hasn't gone down in flames, and people are motivated for November. So I don't see a good outcome politically for the Obama administration.
Today they're debating the issue of severability because the Senate version of the bill, which became law, did not have a severability clause in any part of it. And for those who don't know, generally when you write a law, you put a severability clause in it that will indicate that if any part of the law is found unconstitutional by a court, the rest of the law stands. Because this bill has no severability clause, shouldn't that be a slam dunk that the court would say, well, no severability clause, one part of it's unconstitutional, it all goes down? Why isn't it that simple?
Well, I'm not 100% up to speed on the law on the severability issue, so I don't want to, misstate something. I think that, legislative, as I understand it, legislative intent as expressed in the statute for severability could be conclusive on the aspect of it being severable, but I'm not sure it would preclude a court, the fact that it's not in there doesn't, I don't think, automatically mean that the entire law fails. I think the court probably would have to look at it and see how integral a part of the law this particular provision is. And so I don't know that it's going to be as simple as some people have made it out. On the other hand, I don't want to overstate because I haven't looked into that issue as much as I've looked into the general mandate issue.
You know what I think is kind of interesting, it's curious to me, but generally courts are much more deferential to lawmakers and their legislation than they are to, say, citizen initiative process. Now, I don't know about the rest of the country, but I know here in California, where we have a very vigorous initiative process, there have been a number of times over the past 20 years where citizens groups have come forward with initiatives, Professor, where they have forgotten to include a severability clause, and the judge shows no deference whatsoever to the people. He or she throws out the entire law because one section of it was found to be unconstitutional. So it's interesting as to how judges tend to look at that, giving great deference to the legislators, but not as much to initiatives of the people.
Yeah, a lot of that is, though, through the state court system. And, state courts may not be, have to follow necessarily the same standards in judging propositions and voter initiatives as they do for legislation. So I think you're probably right as kind of a historical matter that courts, particularly in California, have looked for ways to get rid of voter initiatives even after they've been passed. But, I can't say that it's really the same situation the Supreme Court's facing here.
Sure. Oh, no, because we of course, have no initiative process nationally. Our system of government doesn't allow that. But this is, I think, to me, this is the most fascinating Supreme Court case in a long, long time. And one thing I heard yesterday that I thought was, really another interesting aspect of this is that those who were supportive, there were some folks that were on C-SPAN yesterday who were supportive of the mandate and said, "Oh my gosh, if the court strikes down the mandate, the next thing you know, conservative groups are going to come in, they're going to follow on and they're going to try and relitigate the Wickard decision. They're going to go after Social Security. They're going to come after all of these sacred cows that came down during the New Deal and try and overturn 80 years of judicial precedents." Do you see that as actually being likely, or is that just hyperbole?
I think that's hyperbole. I think that if this is thrown out by the Supreme Court, it's in all likelihood going to be based on a finding that this is qualitatively different from what has happened in the past and the sorts of regulations the court has, approved in the past. I don't see the court saying that, throwing the mandate out now is the template for going after other court decisions that have approved regulation of commerce, of interstate commerce. So I don't see that being likely. I think it's going to be perhaps something along the lines of, this is the exception which proves the rule, and that, there's something very different about this mandate than other regulations of the wheat market, or things like that, that this is different. And that's, and based on the questioning, and again, the questioning is not always a good indicator, but based on the questioning, it seems like the swing vote, Justice Kennedy may be leaning towards, throwing out the mandate. But, again, I don't want to read too much into the questioning.
Okay. And if you were a betting man, would you say from what you've seen over the last couple of days that it would indicate that the court would be likely to either uphold the mandate or throw it out?
I'm not a betting man. And I've learned through the school of hard knocks not to predict what a court is going to do.
Especially this court.
the best I can say is based on the questioning by, particularly Justice Kennedy, it looks like there is serious doubt that the mandate will survive, but that's not a prediction.
Okay. Well, and I think you're right to go in that direction because it's hard to figure out where the Supreme Court is going to go on a particular issue. I mean, a number of years ago, I think back in 2005, a lot of us thought that the court was going to overturn the Kelo decision, and they upheld it. And so it just goes to show that when it comes to the Supreme Court, it's just best to wait and see.